Hi, welcome back to Finally Revealed. In this episode, I want to talk to you about the 22 debts or types of debts that you cannot discharge in an individual bankruptcy. Okay, now some of these are going to need way more explanation, but I'm just going to run through these because I don't want to make this video too long, okay? So I'll probably follow up with a couple of other videos to explain it, and leave in the comments if you have questions, and then that'll kind of tell me where we need to elaborate some more, okay? These are in a general basis. These are things that you cannot count on getting a discharge from in a bankruptcy, all right? First, a tax or a customs duty. Next, properties, services, or an extension or renewal of credit or money that was obtained by false pretenses or by commission of an actual fraud or obtained by money obtained by a false financial statement. Next, consumer debt owed to only one creditor, to a single creditor, that is more than $675 for luxury goods or services incurred within 90 days before the order for relief was entered. Okay, number 4, a cash advance totaling more than $950 made on or within 70 days before the order for relief was entered. And this can be more than one, okay, that totals more than $950. Number 5 is debts other than money, property, services, or an extension or renewal of credit obtained by fraud. A debt other than those kind that is not listed or scheduled in time for the creditor to file a proof of claim in time. Now the next one, number 6, is money or debt or services or an extension of credit that was obtained by false pretenses or actual fraud or using a false writing that is not listed or scheduled in time for that creditor to do two things: to file a timely proof of claim and to allow them to file a timely request for determination of the dischargeability of that obligation. So both of those. Number 7, a debt that was incurred by fraud in the capacity of serving as a fiduciary. So if you were an executor of an estate or some other type of fiduciary, or by larceny or embezzlement. Number 8 is a domestic support obligation through a divorce or that type of proceeding. The next one is a willful and malicious injury to another entity or that entity's property. And here entity is a person or a thing, company. Number 10 is a fine or a penalty or a forfeiture payable to a governmental unit and not for compensation or an actual monetary loss, and it's other than a tax penalty that's imposed by a transaction or event that occurred before 3 years before the filing of the bankruptcy petition. That one's a tricky one. Number 11, a benefit or an overpayment or a loan made or insured or guaranteed by a governmental unit or under a program funded in whole or in part by a governmental unit or a nonprofit. Basically, here we're talking about student loans. Number 12 is an obligation to repay funds received as an educational benefit, a scholarship, or a stipend. And that's something that already has to be repaid. You can't get out of it. Any qualified educational loan according to the Internal Revenue Code. Okay, number 14 is a debt for a death or personal injury caused by a motor vehicle, a vessel, or aircraft if it was operated by the debtor in an unlawful way, and the unlawful way is because they were under the influence of alcohol, drugs, or another substance. Number 15 is a debt that was or could have been listed or scheduled in a prior bankruptcy to which the debtor waived the discharge, or was denied a discharge. Number 16, final judgment, an order or a consent order or decree from any court or a settlement agreement arising from fraud while in a fiduciary capacity or a depository institution or a credit union. So this is relating to bankers. Number 17 is a malicious or reckless failure to fulfill a commitment to a federal depository institution, regulatory agency to maintain capital of an insured depository institution. That's another one pertaining to bankers. Number 18 is the payment of an order of restitution. Number 19 is money that is owed to a spouse, a former spouse, or a child of the debtor other than a domestic support obligation, which we already covered, and which was incurred in connection with a divorce or separation agreement or divorce decree or another court order. Number 20, fee or an assessment coming after the order for relief is entered relating to a condo unit or a co-op or a homes association. Now, this does not cover things that were due at the time of filing. At the time of filing, they're going to be discharged. These are fees that are going to be assessed after the filing is made, and so long as the debtor or the trustee is in possession, ownership, or control of the property in question. Number 21 is a fee imposed on a prisoner by a court for filing a case, a motion, or a complaint. And finally, number 22 is a loan owed to a pension, a profit sharing, or stock bonus, or other plan or ERISA loan. Okay, so those are, in very basic terms, debts that you cannot count on being discharged if you file an individual bankruptcy. So if this was helpful to you, give me a thumbs up, share it with someone who might be considering bankruptcy filing. Leave a comment if you have one. Subscribe, please subscribe, and I'll see you again next time. Thanks for watching.